Sharia law in the United States. There has been much heated debate over whether to allow Sharia law in the United States, particularly in matters relating to marriage and the family. Both sides point to the fact that Islamic law, for better or for worse, is already operating in several other countries. But unfortunately, the arguments for both sides are so often reduced to simplistic sound bites. Those against Sharia law usually point to its harsh, cruel penalties. Those in favor of it argue that the United States, a country that prides itself on religious tolerance, is discriminating against Muslims by not recognizing Islamic law. But it is not as simple as either side makes it sound. There are several complex matters at issue here, most notably balancing the interests of American society with the right to religious expression. Politics aside, could Sharia law work legally and logistically in America? There are several basic premises upon which the United States was founded in order to protect a free society. One of the most important of these is religious freedom. First, that the laws of the nation would be secular, and that government would not establish a religion separate of church and state. And second, the people living here would be free to worship as they see fit or not at all. These concepts are embodied in the establishment of free exercise clause of the First Amendment. But as the founding fathers declared in their writings, and as U.S. courts have upheld ever since, rights are not absolute and must be limited in order to preserve the society as a whole. The most well-known example of this exception is free speech. One cannot yell fire in a crowded theater because of the panic that will ensue in endangering the lives of others. The same is true of religion. The founders were quite clear on the point that while there could be no abridgment of thought or belief in one's religious faith, there can and will be limitations placed on one's actions. Actions in the name of religious worship, when they conflict with the laws of the United States, are not protected. There are several aspects of Sharia law that would prove problematic in this country. One example is Sharia law acceptance of polygamy. The recent Der Spiegel article regarding Germany's application of Sharia law illustrates this. Under Sharia law, a man is allowed several wives. German courts will adjudicate such a case, determining whether the wives are entitled to support a portion of the husband's pension or estate in the event of his death. In the U.S., however, this would create enormous conflict, given the fact that polygamy has been illegal since the 19th century. In fact, in recent years, several polygamous laws have been greatly expanded by the government. If American courts were to recognize and afford protection to polygamous relationships created under Sharia law, this would no doubt give rise to numerous equal protection lawsuits by Mormons who believe in polygamy as part of a faith-based lifestyle. Another central concern regarding Sharia law is its treatment of women. There have already been several cases in which U.S. courts have refused to enforce Sharia law in family matters on grounds that it violates public policy. Most recently, Judge Joseph Charles of New Jersey refused to grant a Muslim woman a restraining order against her husband, who had claimed he had sexually abused her. The bias for the judge's ruling was that the husband had no intent to rape her, but was simply following what he believed to be his right under Sharia law. Indeed, under Sharia law, it is considered a wife's duty to make herself available to her husband at all times, as he is not allowed to seek sexual gratification outside the marriage. Not allowing him such access is considered a threat to the core of the marital relationship and a basis for a husband's denial of financial support. However, under the laws of the state of New Jersey, when a man forces himself on any woman, even if it's his wife, it is rape. Therefore, the appellate court overturned Charles' ruling, and the husband was arrested for his crime. In fact, in several past years, more states have moved towards applying the same penalty for spousal rape as when the rapist is a stranger, to allow separate justice for husbands or less protection for wives. Under Islamic law is a contradiction of every notion of equality on which the U.S. legal system is based. Another example in the matter of brotherhood, the 2006 New Jersey case in which a Muslim man sought to enforce In this state, an Islamic divorce decree. The couple married in Lebanon, an Islamic country, but had since lived in several places, including New Hampshire. Under Sharia law, a husband may divorce his wife by telling her 3 times that he wishes to dissolve the marriage. In this case, the husband, after telling his wife he wishes to divorce her, traveled to Lebanon to obtain the divorce decree. While he was gone, his wife filed for divorce and financial support in New Hampshire family court. The husband ignored the action. The court awarded the wife everything she had petitioned for. The New Hampshire court would not recognize divorces obtained in other jurisdictions because the couple had been domiciled in New Hampshire when the divorce was initiated. A state is not going to afford recognition to Sharia law when it does not even afford that recognition to another state. Alimony is another aspect of family law which is treated completely different under Sharia law than in American courts. Under Sharia law, marriage begins with the creation of a contract. Under this contract, the woman is entitled to maintenance by her husband, meaning that during the marriage, he has to support her according to his financial needs. If divorce is commenced, the man is required to support his wife during the waiting period. Once the divorce is final, however, the man is not required to provide any financial support to his ex-wife, regardless of her circumstances. Only if it has been included in the original marriage contract is a woman entitled to support after the dissolution of the marital relationship. Alimony in the United States is, on the other hand, varies from state to state. For example, some states base alimony on the length of the marriage, including common law unions. In some states, fault is a factor. In others, alimony is based solely on financial needs. Support is usually terminated when the party receiving support remarries. But the fact remains, alimony is a matter to be determined by either the court or through mediation on a case-by-case basis. There is also a discrepancy in the laws concerning child custody. Under Sharia law, the mother retains physical custody of the children during the years of dependence. When they reach a certain age, usually 7 to 9 for boys and 9 to 11 for girls, although this varies among different schools of Sharia. The father takes physical custody. The woman can also lose custody of the children if she remarries or converts to another religion. In the U.S., the standard in all matters relating to children is in the best interest of the child. With Muslim women in this country, if deprived of their children once they have reached a certain age, have recourse to the American courts? If not, this would no doubt be a concern to American jurists, particularly in cases of alleged abuse. Several other countries were faced with similar dilemmas, and they allowed Sharia courts to operate alongside their own judicial systems in the form of arbitration. Israel and India, for example, recognize Sharia courts despite the religious disputes that exist in their countries between Muslims and non-Muslims. However, their decisions can be applied to the higher court and may be overturned if they violate basic rights or the laws of the land. But in England, where Sharia courts adjudicate civil matters under the Arbitration Act of 1966, their existence is being hotly contested. Human rights groups, such as One Law for All and Iranian Solidarity, argue these courts and tribunals have created paralegal systems in which Muslims are deprived of rights enjoyed by others living in England. These tribunals operate by consent of the parties mediating cases involving family issues such as divorce, alimony, and child custody. But Iranian Solidarity and other groups point out that Muslim women, who are often at a grave disadvantage under Sharia law, are under immense religious and social pressures to consent. In addition, these decisions are binding, as in any secular court, so there is no hope of appeal if the decision is unfair. There is no reason to assume that in the United States, whose legal system is similar to England, the application of Sharia law would be any different. Another critical factor is the very different natures of religious versus the law. Whereas religious law, such as Sharia, remain unchanged, the laws more in what is considered just in America is constantly in flux. No one would dispute that the U.S. has often fallen short on the ideas contained in this Constitution. But we all would agree that jurists and legislators alike continue to strive to reach those ideas. One area in which we have made great strides as a nation is the equality of women. To allow a particular group of women, be they Muslim or otherwise, to be governed under a separate law that could be construed as inaccurate would be no doubt unacceptable to many Americans. We do not need Sharia law in this country. This is not a Muslim country.